Okay, I believe we are ready to begin. Good afternoon. Welcome to the July docket of the Kansas Court of Appeals. I'm Judge Thomas E. Malone. We also have on this panel Senior Judge Patrick McEnany and Senior Judge James Burgess. We are conducting this afternoon's hearing by Zoom, which is what we do these days under our court's special COVID-19 rules. I'd like to thank the attorneys for your cooperation in participating in the hearing in this manner. Let me make a few preliminary remarks before I call the first case. I remind counsel that we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. As the presiding judge, I'll be the timekeeper. Each side is given 15 minutes for your argument unless it's designated differently on the docket. And I think our second case this afternoon is scheduled for 20 minutes per side. If there's more than one attorney per side that will be arguing, you need to decide in advance how you wish to divide your time. That shouldn't apply to this first hearing. And also the appellant's attorney should let us know when you begin your argument if you wish to reserve any of your time for rebuttal. After you present your argument this afternoon, your case will be deemed submitted for decision. And after that, the court will take the case under advisement and we will get a written decision out to you and your clients just as soon as we can. So with that, I'll call the first case on the docket this afternoon. It is from Sedgwick County. It's number 120930 in the matter of the marriage of Lindsay Madrigal and Daniel Madrigal. This appeal involves an order modifying child support in a divorce action. And who do we have here for the appellant?
Please the court and counsel, Your Honor, Terry Malone appearing on behalf of the appellant, Dan Madrigal.
Okay, Mr. Malone, I'm having a little trouble hearing you, so if you could try to speak up a bit, I think that might help.
Okay, I will do that. Is that any better?
That's a little better.
Okay.
And then also for the record, counsel, even though we happen to have the same last name, you and I have no family relationship. That's correct, isn't it?
Yes, Your Honor. I think we've discussed that once before, maybe.
Just like to make a record.
All right.
And then who do we have here for the appellee?
May it please the court, Your Honor, Lindsay Madrigal, the petitioner appellee, appears by and through counsel Brian Carmen.
All right, Mr. Malone, we will begin with you. Do you wish to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal.
That is granted, and you can begin whenever you're ready.
Thank you, Your Honors. As has been stated already, this case is about the application of the Kansas Supreme Court Child Support Guidelines. And there are essentially 3 issues that were raised on appeal that need to be reviewed by the court, and we think should cause this court to reverse the district court judge. The first issue has to do with section Roman numeral 5 of the guidelines having to do with sanctions. In this case, the mother had filed a motion to increase child support, but also filed a separate motion asking the court sanction my client. And the issue in this case is that because the guidelines places a duty on a parent to disclose a material change in circumstances, and material change in circumstance definition can include many things. And in this case, it includes a change in income. The problem in this case is that the court issued a sanction against my client beginning on January 1st of 2014, and in the subsequent years, 2015, 16, and 17, starting on January 1st, even though he did not have any knowledge of a material change of his circumstances until his tax returns were prepared the following year. And for 2014, that would have been April of 2014, and for 2015 through 17, that would have been October. My client is a self-employed person. He's a real estate agent, and his income, like most income for self-employed persons, isn't lineal. It's not an equal amount. It's not like a salary. So his income fluctuated during the course of a year, as did his business expenses. So he did not have the information or have information about him, a change of his circumstances, until he had a tax return, or he had his professional tax preparers prepare his returns. That's a very significant issue in this case, because the court, by going back to January 1st of the prior year, before he would have had any knowledge of what was going to happen to him in the subsequent 12 months, started calculating the sanction, or what the rules say should be the financial impact of a sanction on my client, by going back to January 1st instead of the time frame when he would have had knowledge of that change in circumstances, which is when the tax returns were prepared. The significance of that is amounts to roughly half of the sanction that the court issued against my client. And we think that the rule in the case law, the Johnson case that interprets it, makes it pretty clear that the sanction shouldn't begin until someone has knowledge of a material change in circumstances, instead of just imposing the sanction beginning on some other arbitrary period of time. The other issue with regard to the sanction that we think the court erred when calculating was the financial impact of the failure to disclose. In this case, what had happened is my client had been spending a substantial portion of his disposable income on the children and their expenses. Not only had there been court orders prior to this hearing, also there had been agreements between the parties that my client was paying for a substantial amount of child support expenses. The evidence in the case was he was spending approximately, on average, $800 a month to support the kids, and the sanction presupposed that the mother was going to pay the direct expenses of the children, which resulted, by the way the court did this calculation, in a substantial windfall to the mother, in that my client got no credit for the money he had paid toward supporting the children for this period of time. So we believe that the court committed error on both of those issues with regard to the application of Section 5 of the guidelines. The second issue that's a pretty major issue in this case is the application of the guidelines and what's called the extrapolation formula, or situations when the party's income exceeds the guideline charts in the child support guidelines. And this was a focus of the litigation and heavily litigated before the district court. After the trial that took place, when the parties presented their evidence, the initial decision of the district court, even though the party's income exceeded the maximum amount, the monthly amount, and extrapolation was an issue, the district court denied the mother's request for extrapolation initially and issued child support orders. After the journal entry was filed, the mother had filed a motion to alter or amend and essentially asked the court to reconsider that issue, and the district court, without hearing any new evidence, reversed itself and changed its mind and decided to extrapolate and order the child support on no new information or no new evidence to begin extrapolating and ordering child support. And that had a substantial effect in this case. There are two minor children. The original child support order after the trial was $1,971 a month, but after extrapolating, the child support went up to $4,164 a month based on no findings. And the evidence in this case, well, not only is there a legal requirement that the court make specific findings when the court is going to deviate from the child support guidelines and to extrapolate, which wasn't done in this case. The evidence in this case was and is that the parents have equal parenting time. All the children's needs in this case have been met. I mean, they were getting counseling, they were participating in all their extracurricular activities, and they were getting also at times whatever extra schooling they might need in terms of mentoring, etc. But there was no evidence of any impact on the relationship between the children and their parents with regard to the disparity in income. the types of issues that are traditionally looked at. Nothing was found. There was no evidence of any of that. And yet the court went ahead and extrapolated and ordered child support beyond the guidelines without making the requisite findings to do that, which we believe also is error. The extrapolation formula in the cases, in particular the Patterson case and the ones decided after that, make it clear that not only should the court consider the financial impact might be on the kids, but is also to guard against windfalls to the receiving parent. And in this case, there was a substantial windfall to the mother, and there was evidence presented of that she had been using the money that she was receiving for extra child support to take vacations without the kids going with her, and in fact had left the children with the father so that she could take these vacations. But the second evidence was essentially what I mentioned a moment ago, which is that there was essentially double dipping going on here, in that my client being asked to pay this extra child support, and the way the timing of it worked, he had been continuing to pay a lot of his discretionary money to support the children. And by then getting hit with this extrapolation order, and the money he had already paid to the mother was credited to him, but the money he had paid towards supporting the children, which there was uncontroverted evidence as, my client wasn't credited with. So the requirement that the court guard against awarding guidelines, or awarding windfalls, I should say, to a parent receiving child support weren't followed in this case. And again, I think that was abuse. We believe that's an abuse of discretion and a misapplication of not only the rules, but the case law that interprets it. So there should not have been extrapolation in this case. The third issue, if I can briefly hit it, and I think I'm about out of time, but the third issue in this case was the statute of limitations, which is found at KSA 60-514C, that limits to 1 year actions based on statutory penalties or forfeitures. In this case, the court went back multiple years and then engaged or entered sanctions against my client. And we believe the rule or the statute of limitations for statutory penalties, which does not contain any language in it that would trigger discovery like there would be for fraud actions, like it's 60-512, I think it's subpart C or D. Since there's no language in the statute of limitations that only triggers its application once a cause of action is discovered, but the application of this should be that to pursue this type of a statutory penalty and sanction against someone, there should be this application of the 1 year restriction, and that wasn't done in this case and should have been. So for the reasons that I fleshed out more in the briefing, but I've described here today, we believe that the district court's decision should be reversed on all three of these reasons, and not only the statute of limitations be implemented, but the extrapolation order be reversed and the guidelines be followed. And number three, that the sanction, if it's going to be calculated, be recalculated based on the application of the language in the rule, that it only sanctions be implemented after a person who's to be punished would have knowledge of the conduct that they were supposed to disclose, or the information they were supposed to disclose, before they could be punished. So if the court has any questions, I'll be happy to entertain them here in my initial segment.
Hearing no questions, thank you, counsel, and we'll proceed with Mr. Carmen. You need to unmute.
Let's try that again. May it please the court, Your Honor, can you hear me?
Yes.
That's great. I would agree with opposing counsel. This case does deal with the Kansas Child Support Guidelines, specifically section VB2. That section places a duty on parents to voluntarily notify the other parents of changes in income, which would constitute a material change in circumstances. The facts in this case would show that in 2012, Mr. Madrigal had income of approximately $103,000. By the time he disclosed his 2017 income 5 years later, his income had increased to $644,000. So we had to file a motion to modify child support and a motion for sanctions to secure that information so that the correct amount of child support could be paid to these two children. Now, in addressing opposing counsel's specific arguments on sanctions and whether they are appropriate prior to knowledge, I would tell the court that the district court ruled in December of 2018 that during a given tax year, the respondent was receiving income at a considerably higher level with knowledge of increases in income as he received them. The respondent could have taken steps to stay apprised of increases in income as it was happening. All self-employed individuals fall within that category. And I think the court could use common sense when it comes to that fact. The testimony at trial was mom requested income information from dad, and that the reply was he said absolutely no. And that if my client tried to secure that information or seek an increase in child support, she would actually get less. My client asserts that but for her filing of this motion, she would have never voluntarily received the tax documents which evidenced this large increase in income. As far as the sanctions go, child support is for the children. If there is an underpayment based upon non-disclosure, there has to be some time frame that the court selects to properly determine an arrearage. The leading case on this is in re Marriage of Johnson, which Your Honor, Judge Malone actually, I believe, was on the panel and wrote the opinion for. There's also a concurring opinion from Judge Powell, a former Sedgwick County District Court judge, who again concurred with the Johnson opinion. I would tell the court that if we are looking at tax returns to determine income, it only is logical to recreate income and child support obligations from a January 1st to December 31st timeframe. That makes sense. The respondent's claims that sanction is not consistent with the dollar value that was based upon respondent's failure to notify. I think in my brief, I covered that the court specifically awarded a sanction based upon an underpayment of child support once the income figures were calculated into a child support worksheet. If we move towards the question about extrapolation, the court held on December 20th, 2018, that there wouldn't be any extrapolation for the sanctionable periods of 2014 to 2017. And the court ruled that it did that to give credit to the respondent for evidence of some of the direct expenses that he had paid. I would also note that the court limited my client's request for attorney's fees based upon that same analysis. Now, at trial, we also had a question about the respondent's 2016 and 2017 income, which was not supplied to my client until after the evidentiary hearing. That led to motions to alter or amend after we had received that information. And the court had what it deemed in the minute sheet was a special setting, but the Court of Appeals will probably frown. It was proceeded by proffer basis in Sedgwick County on January 29th, 2019. And that's where we came up with the additional incomes, and the court updated and extrapolated income for dad, stating circumstances exist to warrant extrapolation of income for child support purposes. And part of the reasons the court extrapolated included that mom was renting a home, that there was travel associated with the kids' activities, that the kids had sports and private lessons, that dad had a home, a boat, and an RV, and that there was disparity between the parents' incomes. This court has previously talked about, especially in the Johnson case, the Kansas Supreme Court Administrative Order number 287. And that administrative order says that if child support income exceeds $15,500 a month, which is the table guideline, that the court should exercise its discretion by considering what amount of child support should be set in addition to the highest amount on the schedule. Now, I would admit that this is discretionary, but that sentence is very, very clear in the administrative order. It's in addition to whatever the normal amount of the schedule of child support says should be applied. The court has previously addressed such issues in an unpublished case, in re Marriage of Wilson, which is located at number 104830. And in the Wilson case, there's Wilson 1 and Wilson 2. In Wilson 1, the court disapproved the use of the 3-pony rule. And the court held that when there's a drastic difference in parties' incomes, which in Wilson was over $2 million, it was likely to have a long-term negative effect on the child's relationship with both parents, giving a parent with money superiority, which would include things like better living, travel opportunities, more education, more recreational opportunities, and that the failure to extrapolate would likely lead to parental conflict. The district court in our case specifically held that the lifestyle of the kids was an important factor when it determined it should extrapolate. That mom was at the poverty level, that dad had a high quality of life. My client is a hairdresser who, throughout all the child support worksheets in this case, has been imputed basically at minimum wage or just over minimum wage. That there were more luxuries at dad's house. That my client had costs associated with raising the kids, with sports, with traveling to the kids' sports. And all that was cited in the court's April 19th, 2019 memo. The father in this case wants to adopt a share the wealth model. That is not the law in Kansas. The father cites to in re Marriage of Leone, a case that's highly distinguishable, for the main fact that in Leone, both parents had substantial assets. And that's not what we have in this case. We have one parent making, in 2017, $644,000, and my client is a hairdresser making less than 20. Statements that my client has incurred a windfall in light of the extrapolated child support are simply not accurate. What is true is my client has been able to purchase a home, a modest home that now is in the child's school district, which is advantageous to the children. My client continues to pay for the direct expenses of the kids. She's recently purchased a car for the children. These are not evidences of windfalls. Did my client go on a vacation? She did. She did. Did that happen to occur after child support was extrapolated? It did. But my client should be allowed to travel. My client traveled for work. She's a hairdresser. And so she went with friends and did for a wedding and did the party's hair. Those things are natural that have no direct line between an extrapolated child support and benefiting the children to the right amount of child support based upon the party's incomes. I would move on to the last argument of opposing counsel, which is the statute of limitations. His brief also talked about latches, and we just don't think that applies. The cases that were cited by opposing counsel are Richardson versus Murray. It's not a family law case. It doesn't involve child support. There's a Stillman case that I've cited in my brief, which we believe does have some applicability, and that the court did imply that you could go back farther than a year, even though the court denied dad's requested relief because he was aware of mom's increase in income. We believe that's distinguishable from our case here. We had no knowledge until 2017 when we filed the motion for sanctions and the motion to modify child support, and had to issue formal discovery of what dad's income truly was. We think that dad has unclean hands in this case. His reply brief talks about the statute of limitations should apply 1 year prior to June 30th of 2017. And in the next statement, he says, well, the father was aware as early as April of 2015 that his income would have modified. But the facts in this case don't evidence that in 2015 he notified my client consistent with the child support guidelines duty to notify. In 2016, he didn't notify my client. In 2017, he didn't notify my client. It took my client to file a motion and move forward to get that. And we think that's unclean hands on behalf of the appellant in this case. He can't have it both ways and claim that he knew there was a material change of circumstances and that mom failed to act. But in reality, that failure to act was directly related to his failure to disclose. This is child support. This is the child's rights. Father's application, we believe in this case, is a potential Pandora's box, and it incentivizes parents to not disclose their increases in income. And I would finish by looking at Judge Powell's concurring opinion in two sections, which I believe are relevant to the court's analysis in this case. Judge Powell states the whole purpose of the sanction provision is to provide an incentive for a party to disclose a material change in circumstances. Without certainty that a sanction will be equal to the benefit gained from a failure to disclose, parties will always have an incentive to conceal material information and attempt to roll the dice in court should their concealment be discovered. Lastly, the duty to disclose a material change in circumstances in the child support context is the linchpin of our child support guidelines because child support is based on both parties' incomes. We think this appeal should be denied. We do not believe there was an abuse of discretion. With whatever remaining time I have, I will happily try to answer any of your honor's questions.
What did you say the numbers were for 2016 and 2017?
As far as dad's income?
Correct.
In 2016, dad's income increased to $495,000. In 2017, his income increased to $644,000.
Thank you.
Hearing no other questions, I guess we will return to Mr. Malone. You still have 3 minutes of rebuttal.
Thank you, Your Honors. To jump into this, the problem with the sanction argument that I've heard is that, again, it doesn't change the fact that the language of the rule and the case law that interprets it still says that before a party should be sanctioned, that they're supposed to have knowledge of a material change in circumstances, and then they're being punished for failing to disclose it. And with a self-employed person like my client, any argument that just because somebody has this general feeling or has some idea that maybe they're doing better some year than another year is misleading, because telling the other parent that, hey, I'm having a better year than I had last year, or I'm having a worse year than I had last year, doesn't help anybody. That information doesn't allow anybody to make a calculation of a child support worksheet to make a determination of whether there has been the 10% change that in the child support where it would be warranted to make a change. There has to be a knowledge of a material change in circumstances, information sufficient that would allow the parties to sit down and make calculations before there's going to be the trigger idea of a duty to disclose. That has to be the rule. Otherwise, what we've got is a situation where people are being punished, like my client was, without having any information that he could disclose. And a person just certainly and must not be in a situation where they're going to be punished for not disclosing something that they didn't have information about to disclose.
We're all attorneys.
That argument doesn't apply.
Don't we normally know when we're having a good year? You get get 2 or 3 big fees, you know you're having a good year. You might not be able to identify specifically what your income is going to be, but you certainly don't have to wait until the tax returns are filed, maybe 1, 2 years later, to maybe notify the other spouse of that she's due for an increase in child support. Isn't that true?
But what would we disclose, Your Honor? If we said,
Well,
you tell your spouse, I had a really big fee come in, but what were your expenses going to be? So how would you change child support based on the fact that one event happened that was really good? And then if you had a really bad case and you lost one that was where you weren't going to get paid or something, you disclose that to the other side as well and say to your spouse and say, gee, I might have a bad year, but we don't have a way of calculating it.
Doesn't your client maintain an accounting system internally that shows month to month to month how they're doing in his business?
Your Honor, there was no evidence in this trial to anything even close to that. I don't know exactly how he's doing it. There's no evidence upon which the court, though, could make that assumption or that finding. That was the point, is that to go back and to average this out on a daily basis even is also unfair, because until people really know how you've done it, if it's going to be a calendar year or a fiscal year, you need to look at that entire time frame, not just one day or 1 or 2 days or even a month in it. Because let's say you did have a great month in your accounting system halfway through the year, it makes it look like you're having a really great year, but then the second half of the year is terrible, and it more than offsets the good 2 or 3 months that you're having. That's the problem for self-employed persons here. I mean, if the rule is going to be changed and say, you look back so that people are constantly having to recalculate this on a daily or a monthly basis, that's a possibility if the rule was changed, but I don't think that's a common sense application, and that wouldn't be a very good system for people that are self-employed. The idea of waiting to the end of the calendar year to see what the reasonable business expenses are and what the receipts were is really the only workable system that should be applied here. And that's what we're complaining about, because otherwise, like in this case, my client got hit back on the first day of the year. He didn't have any way of knowing and forecasting what he was going to do at the end of the year. So it would be inappropriate to sanction him going back that period of time, certainly. And since there was no evidence that he had knowledge that he was having a great year during any of these years, so that he would have some even possibility of disclosing something, there's just no evidence of that. So it's inappropriate that he be sanctioned until he has that information. There's just no evidence in this case that he was purposely keeping himself uninformed. That wasn't the case at all. The other things here on extrapolation I want to at least mention is that in spite of counsel's argument, I invite the court to go back and look at the record. There just aren't any findings in this case that would have supported the case law, the Wilson case, or any of the ones that we've cited in our briefing, that the court made findings that my client's increase in income and making more money was having any effect on the kids, having any effect on the relationship of the kids, was having any effect on them being supported, especially when my client was using his disposable income to spend on it. So,
and that's fine, but if he was making more money, maybe their current needs were being met, but couldn't they had a better life if he had disclosed?
I don't know, but there was certainly no evidence attempted to be presented to that effect at the district court level, and nothing came up to even suggest that that would be the case. If you go back and look at the brief, we didn't really touch on it in argument, but whenever the parties were divorced, my client was hung with pretty substantial tax debts and some other debts of investments that were bad. There was more than $200,000 he was having to pay. And it took him some time to get all that paid. That evidence was presented at the district court level. So there just isn't evidence that which is being suggested here. Maybe my client was either spending the money on himself or wasn't using it for his kids. Quite the contrary. My client's got equal parenting time with the kids. He's a very active parent. He spends a lot of his disposable money on the kids, regardless of his court-ordered child support. So in this case, because of the lack of findings and the lack of any evidence presented which would justify extrapolation, that's what our problem is here. There's no findings that would support those kinds of arguments that maybe there was a good reason why it should happen. And
Do we need express findings from the district court on this point? Is there any case that addresses that specifically?
yes, Your Honor, the Patterson case and the cases I cited in the briefing specifically says that there needs to be specific findings anytime the district court is going to deviate from the guidelines. And in this case, it was even applied, in those cases, it applied to extrapolation. And the reason it's important that there be findings is otherwise, why is the rule even written the way that it is? I mean, why is there a discretion? The court doesn't have to extrapolate. It's a discretionary decision. But if it was going to apply every time that somebody exceeded the guidelines, then we need to rewrite the guidelines and take out the discretionary part of it and just say, whatever your income is, we're going to calculate child support on that regardless of what your income is. And that's not what the rule says. The rule says that once you get past the maximum level of what the child support guidelines say the income is, if you're going to go beyond that, there needs to be specific findings to justify doing it. That was not done in this case and needed to be. It was supposed to be. We could speculate on maybe why it was done, but there is no Kansas case, and I couldn't find any other jurisdictions, frankly, that has this type of a rule, and there aren't very many, but there's no case that says that you should extrapolate every time a person's income exceeds the guideline amount. There is no case, no Kansas case. And the way the rule's written, then because of discretion with the judge, there needs to be findings and some reasons why the district court would go beyond the guideline. So, you know, with the rule being the way it is, it needs to be applied the way that it is. And if we want to change it, we need to change it. Finally, on the statute of limitations, counsel had talked about some kind of unclean hands argument. That wasn't briefed. It wasn't brought up at the district court level. So I think it's an inappropriate argument. But, you know, the statute of limitations says that an action is supposed to be brought more than 1 year after, with more than 1 year past the tolling of the events that would give rise to a claim. And in this case, the court did that. And we raised the argument and it was just simply ignored. I think it does apply. I think that otherwise what happens is prejudicial to people like my client. And if you go back a long time, both the parties testified. They did not keep good records because my client wouldn't have any reason to believe he needed to go back and be able to justify the money, all the money he spent on the kids, even though he was spending quite a bit on it. He didn't keep ledgers or good records. And to allow people to go back years and years and years to make these kinds of claims works to the prejudice of the parties. So there needs to be a limit on it. And there is a statutory limit already, which we should follow. If the court has other questions, I'll be happy to try to address them.
Not hearing any, counsel. We thank you very much for your briefs and your arguments. And with that, this hearing is adjourned. Thank you.
Thank you, Your Honors.